Good morning, friends. My today topic is appeal under CPC. You will find that appeal has not been defined in the whole CPC code. Still, an appeal is a process by which judgment order of the subordinate court is challenged before its superior court. The person filing or continuing an appeal is called appellant, and the concerned court is termed as appellate court. A party to a case does not have any inherent right to challenge the judgment or order of the court before its superior court. Appeal can be filed only if it is specifically allowed by law and has to be filed in the specified manner in the specified court. The expression appeal has not been defined, as I already told, in the Code of Civil Procedure. It is an application, or you can say petition, to appeal for higher court for consideration of the decision of the lower court. It is a proceeding for review to be carried out by higher authority of appeal for the decision given by the lower court. And appeal is a creature of statute. And right to appeal is neither an inherent nor natural right. Now, Section 96 of the Civil Procedure Code gives right to litigant to appeal from a original degree. And Section 100 gives him right to appeal from an appellate degree, that is known as second authority, only in certain cases. Now, Section 109 gives him right to appeal to the Supreme Court, that too in certain cases. And Section 104 gives him right to appeal from orders. Now, coming to procedure for filing an appeal. Who can file an appeal? Firstly, who can file an appeal? Any party to the original proceeding or his or her legal representatives. Any person claiming under such party or a transferee of interest of such party. Any person appointed by the court as legal guardian of the minor. Any other aggrieved person after taking leave of the court. The question is simple. There can be no appeal where there is nothing to appeal about. A party which has availed the benefits under the degree, he has nothing to gain more, so he can't appeal. Second is where there is consent degree. In this case, consent should be lawful agreement or compromise and could even be presumed from the conduct of the parties. Parties whose factum or compromise is in dispute or has not been formulated, that can go for appeal. And parties involved in petty cases, no appeal lies. No legal representatives are entitled to file an appeal against a deceased person. And there are so many others. One thing is clear, where right to appeal is created subsequently. Earlier it was not when we filed the suit. Then this right will not be available to the litigant. So if the suit is instituted prior to such creation of that appeal, then it will not be available to him. So the right to appeal gets vested on the date suit is instituted. A new right to appeal gets created cannot be availed by the party to a proceeding which commenced earlier during the creation of new rights. Now, when we file appeal, the memorandum of appeal that is defined under Order 41 Rule 1, that is important part. An appeal must be supported with a memorandum of appeal, which is a document comprising of the grounds of the appeal. And if we go by the constituents of a valid memorandum of appeal, it should include the grounds for filing an appeal, signature of the appellant or his her pleader, and the attachment of the certified copy of the original judgment. The remittance of the decreal amount or security in the case of money degree. The appellant, with respect to this provision, is not entitled to take any grounds or objection except the ones mentioned in the memorandum. However, the court may accept such objection on its own accord, provided the opposite party is provided with adequate opportunity to contest such grounds. The memorandum of appeal must contain the grounds of objections to the decree appealed from concisely, with a distinct head, without any argument or narrative, and should be numbered consequently. The court has the right to reject or amend any memorandum which it finds to be inappropriate. The court shall record the reasons for such a rejection. Now, coming to appeal from original degree. Appeal from original degrees, which is performed by the appellate court, are preferred in a court which is superior in rank to the court passing the degree. Appeal for such degrees may lie on an original degree passed ex parte. No appeals will be placed if the degree is passed with the consent of the party. The appeal from original degrees lies on the question of law. No appeal lies in any suit of the nature cognizable by the courts of small causes if the amount or value of the subject matter of the original suit is confined to a sum of rupee 10,000. The appellate court may remand a case to a trial court if the latter has dispensed of the case without recording any finding. The decision of the appellate authority is conclusive. If an appeal under this provision is heard by a bench of multiple judges, the opinion of majority will be considered. So majority rule will apply. If there is in the absence of majority, the original degree will stay. Where the bench disagrees on any point of view, the same may be determined by any number of the remaining judges of the court, and decision shall be taken by majority of the judges hearing the appeal, which include the judges who have heard it originally. The judgment may confirm, modify, or reverse the degree. Now, coming to procedure for appeal from original degrees, that is Order 41. The appeal shall be filed in the form prescribed, signed by the appellant, along with a true copy of the order. The appeal shall contain the grounds of objection under distinct heads, and such grounds shall be numbered consecutively. If the appeal is against a decree for payment of money, the court may require the appellant to deposit the disputed amount or furnish any other security. A ground objection which has not been mentioned in the appeal cannot be taken up for arguments without the permission of court. Similarly, any point of fact which was not taken up by the appellant in lower court cannot be taken up in appeal. Appeal lies only against those points which have been decided by the court rightly or wrongly, save where otherwise expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie from every degree passed by any court exercising original jurisdiction, the court authorized to hear appeals from the decision of such court. An appeal may lie from the original decree passed ex parte. No appeal shall lie from a decree passed by the court with the consent of the parties. No appeal shall lie except on a question of law from a decree in any suit of the nature cognizable by courts of small causes where the amount or value of the subject matter of the original suit is as per stated above. Now, coming to second appeal. Oh, I am talking about section 100 and order 42 of CPC. Section 100 of the Civil Procedure Code provides that an appeal can be moved to the High Court from every decree passed in appeal by any subordinate court if the High Court finds that the case includes a substantial question of law. Taking into context, the memorandum of appeal must clearly state the substantial question of law in this appeal. If the High Court deems it to be satisfactory, it may go on to formulate the pertinent questions based on which the appeal would be heard. Also, the High Court may hear the appeal on any other substantial question of law not formulated by it if it feels that the case involves such question. It may be noted that a second appeal is only meant for questions of law and hence cannot be made on the grounds of an erroneous finding of facts. In the absence of any errors or defects in the procedure, the finding of the first appellate court will be considered as final. If the particular court produces evidence to support its finding. Second appeal cannot be made for a decree if the subject matter of the original suit is intended to recover a sum of 25,000. The proper test for determining whether a question of law raised in the case is substantially would be whether it is of general public importance or whether it directly and substantially affects the rights of the party. If so, whether it is either an open question in the sense that it is not finally settled by this court or by the Privy Council or by the federal court or is not free from difficulty or call for discussion of alternative views. Section 100, subclause 5 gives the court the power to hear questions which were not formulated by it, but they form a part of substantial question of law if the court is satisfied that case involved such a question. So, save as otherwise expressly provided in the body of this code or by any other law for the time in force, and appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court. If the High Court is satisfied that case involves a substantial question of law, and appeal may lie under this section from the appellate degree part ex parte. In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. Where the High Court is satisfied that substantial question of law is involved, in any case, it shall formulate that question. The appeal shall be heard on the question so formulated and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve any such question, provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear, for reason to be recorded, the appeal on any other substantial question of law, not formulated by it, if it is satisfied that the case involved such question. Now coming to section 100, capital A. No further appeal in certain cases. Notwithstanding anything contained in any latest patent for any high court on any other instrument having the force of law or in any other law for the time being in force, where any appeal from an appellate degree or order is heard and decided by a single judge of the High Court, no further appeal shall lie from the judgment, decision, order of such single judge in such appeal or from any degree passed in such appeal. Now, coming further, appeal from orders, that is, I am talking about provision under order 43, sections are 1042 to 108. Order has been defined as the formal expression of any decision of a court, civil court, which is not a degree. Thus, an adjudication of a court which does not fall within degree is an order. Appeal can be filed only against those orders which are made appealable. Appeals from orders could be placed with respect to the following pronouncements on the grounds of any defect or irregularity in law. Any order under Section 35A of the Code, allowing special costs and orders under Section 91 or 92, refusing leave to institute a suit of the kind referred to in Section 91 or 92. Any order under Section 95 which involves the compensation for obtaining attachment or injunction on insufficient ground, orders under the code which deals with the imposition of fine, direction of detention, or arrest of any person, except in execution of decree. Appealable orders as prescribed under Order 43. However, appeals cannot be filed based on any order unlisted in Clause A and from any order passed in appeal under Section 100. Therefore, even if the provision of the Order 41 CPC are made applicable to appeals under Order 43 CPC, merely to the power to remind the matter akin to Order 41, Rule 43 CPC gets extended to the appellate court, but in the absence of specific provision, the right of an aggrieved party to file an appeal against such an order is not extended by statute. Provisions of Order 43, Rule 1, Subclause U of CPC are clear and do not allow an expanded reading. It is settled law that right of appeal is a statutory right and does not exist as a general common law right unless specifically provided. Therefore, in the absence of any specific statutory provision, the right to appeal as claimed by the respondent cannot be allowed to an aggrieved party. Sometimes there are persons who are not having money, known as indigent persons. So, appeal by indigent persons is covered under Order 44. Any person who is not capacitated to remit The fee required to file the memorandum may file an appeal as an indigent person. If the court declines the application of a person to appeal in this matter, it may necessitate the applicant to remit the required court fee within a prescribed time frame. In the case of Ramsru versus Union of India and another, the court held that at the stage of hearing of an application, the question to be considered by the court is whether the applicant is an indigent person. If he is, the application will be allowed and memorandum of appeal will be registered. If he is not, the application will be rejected. The period of limitation for presenting an application for leave to appeal as an indigent person to the High Court is 60 days and to other courts is 30 days. The limitation starts from the date of decree appealed from. Now, coming to appeal to Supreme Court, that is covered under Order 45 and Section 1092 Appeal to India's highest jurisdictional body can be made if the former considers the case to be appropriate for an appeal to the Supreme Court or when a special leave is granted by the Supreme Court itself. Appeals can be filed to the Supreme Court by filing a petition with the court which enacted the decree, upon which the petition would be heard and disposed of within a period of 60 days. Petitions submitted for this purpose must state the grounds of appeal. Also, it must include a plea for the issuance of a certificate stating that the case involves a substantial question of law which needs to be decided by the Supreme Court. The opposite party will be provided with an opportunity for raising any objection against the issue of such certificate. The petition would be disposed of if the applicant is denied the certificate. If accepted, the applicant would be required to deposit the required security and costs within a prescribed time frame. After the applicant performs the above obligation, the court from whose decision an appeal is preferred shall declare the appeal as admitted, and intimation of which will be addressed to the respondent. Further to this, the jurisdictional body forwards a precise copy of the record under seal and furnishes a copy of such paper in the suit. The pendency of an appeal to the Supreme Court does not affect the right of the decree holder to execute the decree unless the court otherwise directs. The court may stay execution after taking sufficient security from the appellant, or it may allow the decree to be executed after taking sufficient security from the respondent. Now, conditions. An appeal would lie to the Supreme Court under Section 109 of the Code only if the following conditions are fulfilled. First one is a judgment, decree, or final order must have been passed by the High Court. Secondly, a substantial question of law of general importance must have been involved in the case. Third one is, in the opinion of the court, High Court, the said question needs to be decided by the Supreme Court. Appeal under Constitution over and above Article 132, 133, 134A, 136 of the Constitution confer very wide and plenary power on the Supreme Court to grant special leave to appeal from any judgment, decree, determination, sentence, or order, final as well as interlocutory, passed by any court or tribunal. Section 112 of the Code saves the power conferred on the Supreme Court by the Constitution and declares that nothing in the Code of Civil Procedure would affect those powers. Now, cross objection. I am talking about Section 41 and Order 41, Rule 22. Cross objection is like an appeal. It has all the trappings of an appeal. It is filed in the form of memorandum and provisions of Rule 1 of Order 41 of the Code. So far as these relates to the form and contents of the memorandum of appeal, apply to cross objection as well. Court fee is payable on cross objection like that on the memorandum of appeal. Provisions relating to appeal by indigent person also apply to cross objection. Even where the appeal is withdrawn or is dismissed for default, cross objection may nevertheless be heard and determined. Respondent, even though he has not appealed, may support that decree on any other ground if he wants to modify it. He has to file cross objection to the decree, which objection he could have taken earlier by filing an appeal. Now, time for filing objection, which is in the nature of appeal, is extended by 1 month after service of notice on him of the day fixed for hearing the appeal. This could time also be this time could also be extended by the court, like in appeal. So cross objection is nothing but an appeal. A cross appeal, we can say. It may be that the respondent wanted to give quittance to the whole litigation by his accepting the judgment and decree or order. When, however, the other party challenged the same by filing an appeal, statute gives the respondent a second chance to file an appeal by way of cross objection if he still felt aggrieved by the judgment and decree or order. In Jayaram Reddy and another versus Revenue Divisional Officer and Land Acquisition Officer, Kurnool, this court was considering the nature of cross appeal and cross objection. It said the cross appeal and cross objection provide two different remedies for the same purpose, and that is why under Order 41, Rule 22, cross objection can be preferred in respect of such points on which the party could have preferred an appeal. If such be the position of cross objection and cross appeal, a differentiation in the matter of their treatment under Rule 3 and 4 cannot be justified merely on the ground that, in case of cross objection, they may form part of the same record, while cross appeals are two independent proceedings. In Ramasre Singh's case, the court held that, in our view, where nothing is stated expressly as to the procedure of an appeal before a district judge, the law will import that the ordinary procedure of that court on appeal would apply. The ordinary procedure of an appeal is that the respondent has the right to file cross objections. Therefore, it is quite clear that the respondent has the right to file cross objection. And another case that is known as Collector Varanasi case. This case, in a brief order, said we have heard learned counsel for the party. The short question is as to the admissibility of cross objection under the provision of UP Nagarpalika Adhiniyam 1959. where an appeal against quantum has been filed and the respondent has not preferred an appeal. We have looked into the provisions of the section 377, 379, 381 of the Act are inclined to take the view that provision of the Order 41, Rule 22 of the CPC would be inconsistent with the provision of the Act in as much as appeal is admissible only by a certificate or special leave as provided in the provision A and B respectively of the section 381 subclause 1. So it is difficult to contend that a cross objection is anything other than an appeal as generally understood in law. So coming to conclusion, the although the expression appeal has not been defined in the Code of Civil Procedure, we can say it is an application or petition to higher court for the consideration of the decision of lower court. It is proceeding for review to be carried out by the higher authority of the decision given by the lower one. It is an creature of statute, and right to appeal is neither an inherent nor natural right. As soon as the judgment is pronounced against party, right to appeal arises. Right to appeal does not arise where adverse decision is given, but on the day suit is instituted. That is, proceeding commenced, right to appeal gets confirmed. It can be said that right to appeal is appeal substantive right vested in parties from the date suit instituted. So this is all about appeal from lower court up to our honorable Supreme Court. Thank you for watching. God bless you all with good day. See you again in the